This is a short film from DHF on the subject of managing repair and maintenance within the law, and is based on extracts from Section 5 of DHF TS 11 or DHF TS 12 2019. We'll start with a brief history of guidance on this subject. DHF have been delivering training since about 2013, and in the early days of a DHF course, the message from us was quite simply, if a system will not be safe on completion of a maintenance task, do not start that task. And that was based on advice from HSE at the time, and also took account of prosecutions that had come out prior to that time, whereby maintenance companies had been prosecuted in the criminal courts for in fact leaving systems in an unsafe condition in service. So that was the message. That was the best advice we could gain at that time. There is a problem with that though, of course, and that was that companies who were operating within the advice and hence the law were in fact walking away from work that was then being done by others who either didn't know about the law or in fact did not care. So by 2016 we managed to convince HSE that there was in fact a problem and that we would need to come up with a better system for managing maintenance whilst keeping all parties concerned within the law. So in consultation with HSE, we produced a new system and published it first in 2016, so a little while ago now. Anyway, we're going to explain that system to you now. The system that we came up with simply made sure that all stakeholders in the process could manage their own responsibilities within the law. And of course, owners have responsibilities under the workplace legislation and things like the Health and Safety at Work Act, both meaning that they will need to keep their systems safe and subject to maintenance, whilst also the maintenance companies have similar responsibilities based around the electricity at work legislation, making sure that systems will in fact need to be switched off for maintenance, at least for basic electrical safety visual inspections. And then of course, due to things like the Health and Safety at Work Act, they will need to make sure, well, various things, but to make sure that their employees are safe whilst they're working, to make sure that the system will be safe for others who may encounter it after work. They will need to be informing their client about the safety of the system, and they must leave systems they have worked on in a safe condition. Of course, both parties could still also be affected by civil action. They could be sued for negligence should something they do or fail to do result in injury or damage to property. In any management of maintenance system, we have to keep in mind that any system under maintenance is of course the property and responsibility of the client. They also have other legal responsibilities to consider. This might be around things like security or safeguarding. And they also have to take account of. These things are the client's responsibility, however, and not the maintenance company's. The maintenance company also has no legal right to deny a client access to their system. So there's no question that we can stop people using systems in an unsafe condition. The maintenance company's legal responsibilities are to work safely, of course, to inform the client accurately about the safety of the system they're working on, to offer solutions or quotations, and to make sure that they leave systems they have worked on in a safe condition following that work. So in order to manage this, we had come up with a traffic light system. And this brought into consideration the concept of safety critical or requiring improvement. Now this was borrowed from things like the lifting equipment inspections where such systems are used, and this came at the suggestion of HSE. And what we've come up with is this, that where a system is deemed to be safety critical, defects with the system then we should not be restoring that system to service in that condition. So if it's safety critical, it should not be going back into service. If it's at a status of requiring improvement, then it could be restored to service, but only under the express instruction from the owner or manager, or client, in other words. And of course, if it is safe and compliant, then indeed it can be left in service, no problem at all. The maintenance company should always explain the safety issues and of course how the system has been isolated or otherwise made safe. This is so that the client has not been denied access to the use of their system. The requiring improvement status does cause some consternation over time, so we're going to take a little more time to explain that perhaps more clearly. Requiring improvement is neither safe nor compliant. It simply means not immediately lethal. Normally applied to defects that could easily become lethal if just one more thing were to go wrong or some inadvertent action or damage were to occur. This is why requiring improvement defects are only left in service if the client requests it so. There's still a degree of risk for the client and of course for users because these systems are neither safe nor compliant. Okay, so the process that we came up with comes in 4 steps. Step 1 is before going to site, the maintenance company should explain to the client that they will need to switch the system off for safety inspections, primarily around electricity, and also that they cannot leave a system with safety critical defects in service, and this of course to satisfy the maintenance company's responsibilities under Section 3 of the Health and Safety at Work Act. This should all form part of general terms and conditions. We are of course very good at explaining to our clients what things are going to cost, things like response times or call out charges, but we should also be adding these 2 points into our terms and conditions so that our client is not surprised when a system is deemed to be unsafe or cannot be left in service. So the next step, step 2, is the diagnosis stage. So it means going to site. Now, if we judge that a system will be safe on completion of the contracted work we're there to do, then of course we just get on with it. But if we judge that the system will not, or perhaps may not, be safe on completion of the work we've been asked to do by the client, then the maintenance company has some more to do. They must try and decide what diagnostic work may be necessary. Most systems will need to be functional for an accurate assessment to be completed. Hence, faulty drive units, control panels or safety devices will need to be replaced before a thorough assessment is indeed possible. And of course that would then allow us to work out what else could be needed to make it fully safe and compliant. So we will also need to inform the client of defects and any known remedies. We should not restore the system to service if it has safety critical defects, and the maintenance company should then request clearance to execute the necessary diagnostic work or remedial work, and ultimately with the aim of making sure the system can be safe at some point in the future. So step 2, the diagnosis stage. Step 3 goes on to do the work as directed by the client. So if we're requested to execute only the contracted or diagnostic work, because in many cases the client may even need to tender for the remedial works, then the maintenance company should not restore the system to service if it is in a safety critical condition. They should explain how the system has been isolated or otherwise made safe such that the client is not denied access to their system. They should issue an unsafe system notice, whether the defects with the system are safety critical or requiring improvement, and the maintenance company must leave the system in a safe condition in order for them to comply with Section 3 of the Health and Safety at Work Act 1974. So this left in a safe condition statement, this will depend on the specific problem really. It depends what's wrong. It could include reversion to manual. It could be reversion to or provision of hold to run. It could include securing against collapse, or indeed leaving electrically isolated or switched off. Just some caution here though, of course, beware. Leaving switched off achieves nothing in terms of safety where the problem is potential structural failure. So left in a safe condition means left in a safe condition, not necessarily just switched off. An unsafe system notice is a document used by a maintenance company. It explains to the client that the system's not safe. It explains why we are saying this. It identifies whether the defects in question are at a status of safety critical or requiring improvement, and it contains a brief outline of the legal position so that the client can be fully informed of the problem. And we recommend that this notice is issued to the client by email in order to maintain a document trail should the maintenance company need such a thing in the future. On site, well, the system can be left with a sign or a label, a tag of some sort that explains that the system is unsafe, and any such labeling should include the company's name and contact details. Don't just put a do not use sign on things, but explain who said so and when. Okay, now at this point, of course, the maintenance contractor has finished his job and can indeed leave site, and it's now over to the client to decide how they would like to proceed on their site. If on a subsequent visit to the site, the maintenance company discovers that the system is in fact still in service with safety critical defects, then they should simply repeat steps 2 and 3 all over. They will re-inform the client about safety. They will explain how the system has been isolated or made safe. They will not restore the system to service if it has safety critical defects, and they should reissue or issue an unsafe system notice to the client. Then, if a client in possession of the facts elects, wishes, or indeed needs to keep such a system in service, they should be doing so entirely at their own volition and sole responsibility. And they should not be expecting the maintenance company to breach criminal law in their service. In plain language, it means that if they wish to continue to use the system, they will have to come and switch it on themselves. In order to decide what defects may be safety critical and which ones may be requiring improvement, well, we've listed them in the appropriate DHF Code of Practice. So DHF TS 11 2019 for automatic gates and barriers, and DHF TS 12 2019 for industrial doors and domestic garage doors. So in there, in the appropriate section, in both cases it's the end of section 5, you will find a table of safety critical and requiring improvement defects. More detailed information on the law pertaining to maintenance can be found on the DHF website on a page there, law relating to maintenance. You can find that at dhfonline.org.uk. And you will also find on the DHF website a FAQ page. So that's automatic door, gate and barrier frequently asked questions. You'll find it's about 20 or so frequently asked questions there with their answers, and you can also click a button there and download the FAQs as a PDF, which you could perhaps share with others or maybe pass on to your client even. And also on the HSE website, there is a page on responsibilities, legal responsibilities. It says powered gates, but of course it applies equally to doors, gates and barriers. The same laws apply in equal measure. So there's advice there for owners and occupiers, for landlords and for maintenance companies. And then there's also an HSE FAQ page. and that will include some information for domestic householders. It simply explains that there's no health and safety law for them as domestic householders, but they should still be keeping their gates in safe condition, but also explains that the people doing maintenance work are bound by the criminal law and hence will need to leave the system in a safe condition. So that's some advice for domestic householders. So that brings us to the conclusion of this short film. It should result, if people apply this system on site, it should mean that the only reason that an unsafe system is in fact in service is that the client or the owner has chosen to put it back in service themselves and not the maintenance company. And the maintenance company will have informed the client, they will have assessed the system, and they will seek instruction from the client as to how they would like them to proceed. They will then proceed as instructed, but will need to leave the system in a safe condition. So that means they can do whatever work the client asks them to do, but it also means that they will need to leave it in a safe condition. And then if at repeat visits they find the system still in use in an unsafe condition, then they will simply repeat the process. They will issue or reissue unsafe system notices. They should explain how systems have indeed been made safe so that the client has access to the system. They should provide solutions and of course always leave in a safe condition. Okay, well, thank you for taking the time to listen. I hope it's been informative to you, and you can always find more information on all subjects and all areas of DHF work on the DHF website, dhfonline.org.uk. There's a whole mine of information available there, from documentation to training, CSCS cards, news, membership details, and various other information across the wide spectrum of DHF's coverage. Okay, so thank you for taking the time, and please do get in contact with the DHF if you think we may be able to help you in some way. Thank you very much.